At present, it is noticeable that a group of lawyers have developed a tendency of filing PIL. Distressed and deprived. এই দুইটা জিনিস হলো আপনাদের দেখতে হবে, distressed and deprived. PIL is not defined in any statute or any act. It has been interpreted by judges to consider the intent of public at large. যেটা আহসানুল করিম সাহেব at large-এর কথা বলছে। PIL has enlarged and encircled, enriched the traditional doctrine of locus standi and had opened new remedies and procedures. The idea of the PIL is very unique in its nature and remedies within the legal arena. The evolution of PIL emanated from realization of constitutional obligation by the judiciary towards the best section of the society in the larger interest of the people. The judiciary realized that because of extreme poverty, a large number of sections of society cannot approach the court. The fundamental rights have no meaning for the large number of sections of the society. And in order to preserve and protect the fundamental rights of the vulnerable sections of the society by judicial innovation, the courts by judicial process started giving necessary directions and passing orders in the public interest litigation. In the name of public interest litigation is intended to promote and vindicate public interest, which demands that violation of constitutional or legal rights of at large number of people who are underprivileged, ignorant, or in a social and economically disadvantaged position should not go unnoticed and unredressed. PIL is a challenge and an opportunity of vulnerable section of the community to ensure their social and economic justice. The judicial rule in relation to socio-economic legislation was initially marked by regression. A conspicuous feature of judicial process in India is emergence of public interest litigation, or some prefer to term of social action litigation. বেরোপারি কেসটা সবাই জানেন আপনারা যে এই কেসে এনে লুকাস টেন্ডার প্রশ্ন আসছিল। এই প্রশ্নটা আমরা পরে বলতেছি, কিন্তু এর পরবর্তী 1975 সালে এসপি গুপ্তা ভার্সেস ইউনিয়ন অফ ইন্ডিয়া, হুইচ ইজ প্রপারলি নোন এজ জাজেস ট্রান্সফার কেস, মানে এক হাইকোর্ট থেকে আরেক হাইকোর্টে বদলি করে দেয়। এটার মধ্যে পিক অ্যান্ড চুজের বিষয় আছে। দেখা গেল যে দিল্লি হাইকোর্ট থেকে তারে দেখা গেল মেঘালয় হাইকোর্টে ট্রান্সফার করে দিছে, কিন্তু সে ওয়াইড ক্যারি করে যে সে দিল্লি হাইকোর্ট থেকে বড় জোর আপনি কলকাতা হাইকোর্ট অথবা মাদ্রাজ হাইকোর্টে যাইতে পারে, ওটা সিরি এ অনুসারে, কিন্তু তারে দেখা গেল একটা পানিশমেন্ট ট্রান্সফার করে দিল সে মেঘালয় হাইকোর্ট। এই ধরনের কিছু বিচারকদের নাম আছে আমার কাছে, এগুলো আমি বলতে চাই না, তবে আমি এটা হলো জাজেস ট্রান্সফার কেস। The Supreme Court entertained petitions by lawyers wherein it is held that ওটা আমি ডট দিয়ে সারিয়ে দিতেছি। Similarly, in People's Union for Democratic Rights versus Union of India, which is popularly called as a Asiad workers case, এটা একটা কয়লা খনিতে কাজ হইতেছিল, ওই শ্রমিকরা ব্যাকওয়ার্ড শ্রমিকরা তাদের পক্ষে আইছিল, এটা পিআইএল করছিল, পাবলিক ইন্টারেস্ট লিটিগেশন, এবং তারা ওই শ্রমিকের যে এমপ্লয়েড কনস্ট্রাকশন ওয়ার্কার যে প্রজেক্টটা ছিল ওই প্রজেক্টের শ্রমিকরা জিতছে তখন। তার পরবর্তীতে কেস আসছিল যে বাবুরাম বার্মা ভার্সেস স্টেট অফ উত্তর প্রদেশ। The court stated the expression public interest in common parlance means an act beneficial to the general public. হ্যাঁ, জেনারেল পাবলিকদের পক্ষে এই পিআইএলটা তারা অ্যালাউ করছে। এখন এটা আমি এই মুহূর্তে হিস্টোরিক্যাল ব্যাকগ্রাউন্ড অফ দ্য পিআইএল, এটা ইউনাইটেড স্টেটস অফ আমেরিকা তারা পিআইএলটা কীভাবে দেখে এই ব্যাপারে আমি একটু উল্লেখ করতে চাই। যে ইন 1876 সালে, একটু লক্ষ্য করেন মিস্টার শাহজাহান সাজু, 1876 সালে লিগেল এইড মুভমেন্টস হয়েছে ওখানে। Legal aid movements were started by interested persons to assist recently arrived German immigrants. যেটা হচ্ছিল আমার ট্রাম্প বুঝছেন ট্রাম্পের পূর্বপুরুষও হিন্দে আসছে জার্মান থেকে It became institutionalized and became concern of community financed by third parties. At the turn of 20th century, the movement developed to check evils of unregulated business. Institutions developed to define collective rights, and new legislation were being passed. Another route directly in ACLU, American Civil Liberties Union, and its offshoot, NAACP/LDF, National Association for Advancement of Colored People. বুঝছেন ওইটাই লোক মেইন সমস্যা colored people are Legal Defense and Education Fund. After 1939, NAACP became free from parent organ and initiated move for right of the colored. 1954, the landmark case Brown versus Board of Education was fought and won against racial segregation in education. মানে এডুকেশনের যে রেশিয়াল এটা ছিল বর্ণ বৈষম্যটা ছিল ওইটার বিরুদ্ধে তারা জিতে গেছে এমপ্লয়মেন্ট অ্যান্ড হাউজিং In the result, Federal Commission on Civil Rights was formed in 1958 and Civil Rights Act 1964 was passed. In 1963, in the case of NAACP versus Button, was fought which removed legal obstacles to public interest litigation. Main focus of action was on social reform. It may be mentioned here that most of finance is vital in respect of PIL, and financing was done by charitable organization, Sierra Club, Legal Defense Fund, Ford Foundation. এই Ford Foundation কিন্তু আমাদের দেশেও ওই যে ইয়াদের বৃত্তি দেয় বিভিন্ন Ford Foundationের and context of UK. At first, legal aid activities entrenched in England since 1949. In 57, in the Thames Magistrate case, Court of England enabled a newspaper seller to be a person aggrieved in respect of a dispute over a pitch on the street market. This was followed in R versus Puddinglong and developed in Blackburn's case in 1960. In 70s, legal aid and advice scheme was formulated and it was entrusted to Association of Solicitors by the Legal Aid Assistance 1972. The Legal Aid Act 1974, social action groups like Child Poverty Action Group, Joint Council for Welfare of Immigrants, Shelter etc. started taking issue to courts of England and Europe. By way, there was rise of institutions like Parliamentary Commission of Administration about complaint against central government, health service, local authorities, and police. Voluntary small claims courts for consumers. Office of Fair Trading for consumers to regulate trade and protect consumers. The use of PIL, public interest litigation, in England has been comparably limited. Lord Denning, as a senior jurist, respected English judge, gave it a quote, a proceed in 1977 and 81 on Lucas Tendai rule, and PIL was retained with the glory. Context of India. After emergency period of 1975-77, the concept of public interest litigation was initiated by Justice Krishna Iyer. In Mumbai, Kamar Sabha versus Abdul Bai, Justice Iyer stated, test litigation, representative actions, pro bono publico, and like broadened forms of legal proceedings are in keeping with the current ascent on justice to common men and necessary incentive to those who wish to bypass the real issues on merits by suspect reliance on peripheral procedural shortcomings. That is, public interest is promoted by a specious construction of a locus standi in our socio-economic circumstances. It is the first case in India as PIL. The question of PIL was elaborately discussed in the case of Sunil Batra versus Delhi administration, which relates to a prisoner's letter describing torture upon another prisoner. In the case, Justice Iyer stated that it was said that continuously keeping a prisoner in fetters day and night reduces the prisoner from a human being to an animal, and that this treatment is so cruel and unusual, and that the use of bar fetters is an anthem to spirit of Constitution. Thereafter, in several other cases, the concept of Justice Iyer with regard to PIL was carried through in their subsequent judgment by different judges. A charge on confining for more than the period of sentence is Husni Ara Khatun versus Home Secretary of Bihar. আমি ডট ডট দিয়ে করে দিতেছি রিসেন্ট ট্রেন্ড অফ ইন্ডিয়া, আমরা ডট ডট দিয়ে দিতেছি, সব কিছু পড়া যাবে না, অনেক বড় এটা। ইন দ্য কেস অফ TK Ranganarayan and others versus State of Tamil Nadu and others, it was held that there is no question of having any fundamental legal or equitable rights for workers to go on strike, and the employees have to adopt other alternative methods of redressal. In the state of Karnataka and others, Umma Devi, the court held that workers, even after being employed for years together, are not entitled to regularization. In MC Mehta versus State of Tamil Nadu, a petition under Article 32 of the Constitution, আগেই বলছি যে এই 32টা হলো শুধু ফান্ডামেন্টাল রাইটস ভায়োলেশন হইলেই একমাত্র সরাসরি সুপ্রিম কোর্টে করা যায়, ইন্ডিয়ান সুপ্রিম কোর্ট, was brought before the Supreme Court by way of public interest litigation, and it was connected with employment of children in maize factories of Sivakasi in Tamil Nadu state. The court observed that employment of children within the maize factories directly connected with the manufacturing process up to final production should not at all be permitted. Where the court entertained petitioners by MC Mehta, most of the cases brought before the court by way of PIL, the courts of India have been pursuing a liberal attitude towards the pro bono public litigations, and thereby for enforcement of fundamental rights or legal rights of the vulnerable sections can approach the court for their grievance. In the context of Pakistan, public interest litigation has reached to its principle in Pakistan and is developed in late 80s. In the case of Mrs. Benazir Bhutto versus Federation of Pakistan, is regarded as the first landmark judgment in respect of PIL initiatives in that country, wherein the Supreme Court held that as the Article 184(3) of the Pakistan Constitution, এটা কিন্তু 62 সালের Constitution, এই যে 84(3) is open-ended. The proceedings could be maintained by an individual whose fundamental rights are infracted or by a person of bona fide alleging interaction of fundamental rights of a class or a group of persons, as there is no rigid incorporation of notice of aggrieved party in Article 184(3). In Darshan Mashi versus State, where the Supreme Court of Pakistan, on the basis of telegraph, arrogated to itself the jurisdiction to enforce the fundamental rights. ওই যে টেলিগ্রাফের মাধ্যমে একটা চিঠি দিছিল চিফ জাস্টিসে, তখন সে এটা কগনিজেন্সি নিচ্ছে, নিয়ে সোমোটো সে একটা ইস্যু করছে। এর পরবর্তী হিয়ারিংয়ের যে অবস্থাটা হয়েছে দেখেন, টু এনফোর্স দ্য ফান্ডামেন্টাল রাইটস bonded laborers in brick-kiln industries. In particular case of petitioner standing was maintained. Context of Bangladesh. The Supreme Court of Bangladesh, আমি এটা অনেক আগের লেখা যার কারণে আমরা ওই যে কেসটা দিতে পারি না, এই যে ফতোয়া কেসটা, has done a commendable job by protecting the rights of a large number of people who are poor and downtrodden by using PIL as an effective tool. The court has innovated new methods and devised new strategies for the purpose of providing access to justice to large number of people who are denied their fundamental rights guaranteed under the Constitution. The very first case in which the question of Lucas Tendai was addressed and examined by the Supreme Court of the Bangladesh was the famous case of Qazi Mukhlisur Rahman versus Bangladesh and another, popularly known as Berubari case. Mr. Ahsan jeta mention korche. In that case, an agreement entered into Bangladesh and India on 16/5/1974, which was challenged by the petitioner. Mr. Siam, Chief Justice, allowed Lucas Tendai and observed in this regard that the petitioner raised a question affecting a constitutional issue of grave importance, posing a threat to his fundamental rights that pervade and extended to the entire territory of Bangladesh. This creative interpretation of our apex court, the question of Lucas Tendai, preceded even the earliest PIL case in the subcontinent. It is first case subcontinent. Said A.K.M. Nurul Islam. Standing was denied. Mr. M.S. Ali held, Justice M.S. Ali held, therefore the office of the Vice President cannot be held to be included in the service of the Republic. In the service of the Republic, within the Article 152 of the Constitution. Similar view was taken in M.G. Bhuiya versus Bangladesh. An advocate of the Supreme Court filed an application under Article 102 of the Constitution by way of PIL, seeking a declaration that General Notification dated 25/4/1979, which gave effect to the Law Reforms Ordinance 1978, with effect on 1/6/1979, was without lawful authority, with ordinance as ultra-virus of the Constitution. In this case, Lucas Tendai was questioned by the High Court Division and affirmed by the Appellate Division. Moreover, similar view had been taken in M. Salimullah versus Justice Muhammad Abdul Quddus Chowdhury. Appointment of Justice as Joint Secretary was challenged. Bangladesh Songbatpotra Porishod versus Government of Bangladesh. Constitution of OIS Board was challenged. Standing was denied. Chief Justice Mr. Mustafa Kamal held association was not disabled or disadvantaged and hence left the door open for the disadvantaged. Appellate Division's observation in Songbatpotra case was relied upon as tantamount to a verdict against maintainability of PIL under the scheme of the Constitution of Bangladesh. In Syed Mahbub Ali versus Bangladesh, lawyers challenged promotion of judges of subordinate courts without consultation with the Supreme Court, held no standing of the advocates. In Dr. Ahmed Hussain versus Bangladesh and others, reservation of seats for women in the parliament was challenged. Lucas Tendai was denied, and eviction of sex workers was challenged in Sultana Nahar versus Bangladesh, failed standing on merit. At present, it is noticeable that a group of lawyers have developed a tendency of filing PIL petition in the name of public interest litigation on behalf of persons or organizations challenging the propriety of the government in taking decision relating to policy matter, its development workers, orders of promotion, and therefore of public servants, imposition of taxes and fixation of tariff value by the authority for achieving dubious goal for generating publicity for themselves or to create public sensation. Though in respect of PIL, the principle settled by our apex court in landmark judgments, Mohiuddin Farooq case, Professor Muzaffar Ahmed and Mrs. Sayyida Rizwana Hassan case. It is also noticeable that after seeking an order from the High Court Division by filing a PIL, the lawyers are appearing before the electronic and print medias, provocating that the court has made such directions, which suggest that those petitions had not made for the case of the needy or underprivileged or less opportunity people who could not seek redress for a wrong done by the government or local authority. Rather, it were moved for achieving dubious goal for generating personal publicity. Our apex court declared specific parameters within which the High Court Division should extend its discretionary jurisdiction in entertaining a public interest litigation. In that view, the Appellate Division, in the NBR versus Abu Said Khan and others, 18 BLCAD, page 117, Mr. Justice S.K. Sinha allowed locus standi, but some categories of cases which will be entertained. The following some categories of cases are: A, for protection of the neglected children, non-payment of minimum wages to workers and exploitation of casual workers, and complaints of violation of labor laws, except in individual case. Petition complaining death in jail or police custody or caused by law enforcing agencies. D, petition against law enforcing agencies for refusing to register a case despite there are existing allegations of commission of cognizable offences. Petitions against atrocities on women such as bride, burning, rape, murder for dowry, kidnapping. Petitions complaining harassment or torture of citizens by police or other law enforcing agencies. Petitions pertaining to environmental pollution, disturbance of ecological balance, drugs, food adulteration, maintenance of heritage and cultural antiques, forest and wildlife. Petitions from riot victims. Conclusion. This scenario of PIL gradually changed by the judicial pronouncement by our apex court through judicial review. It is the bounded duty and obligation of the courts to encourage genuine bona fide PIL petitions. The court must be careful to see that the petitioner who approaches it is acting bona fide and not for personal gain, private profit or for political or other oblique consideration. The court must also take care to see that it does not overstep the limits of its judicial function and trespass into the areas which are reserved for executive by the Constitution. আমি শেষ করার আগে একটা কথা বলবো শুধু সবার জ্ঞাতার্থে যে আমাদের যে এখন যে অবস্থা আমরা বিরাজমান এবং আমরা কোর্টগুলো চলতেছে ফাংশন করতেছে যখনই আদালত সুপ্রিম কোর্ট অথবা হাইকোর্ট ডিভিশন অথবা আপিলেট ডিভিশন তার কনস্টিটিউশন সাংবিধানিক দায়িত্ব পালন না করে কোনো জজ তখন সমাজে বিশৃঙ্খলা সৃষ্টি হয় এবং রুল অফ ল ব্যাহত ঘটে এই ধরনের একটা উদাহরণ দিব শুধু আমি আপনারা সবাই জানেন 30-এর দশকে জার্মানের যে নাজি পার্টি যখন ক্ষমতায় আসছে নাজি পার্টি এসেই তারা কমিউনিস্ট পার্টি এবং ইহুদিদেরকে একটা নিধন শুরু করছে যখন ইহুদি এবং কমিউনিস্ট পার্টি নিধন শুরু করলো তখন জার্মান কোর্ট এন্টায়ার ফেল করছে জার্মান সুপ্রিম কোর্ট জার্মানের উচ্চতর আদালত তারা এইগুলাকে প্রোটেকশন দিতে পারে না যার ফলশ্রুতিতে দ্বিতীয় বিশ্বযুদ্ধ যার ফলশ্রুতিতে কোটি কোটি মানুষ মারা গেছে তা আমরা সবাই করবো যাতে আমরা 18 কোটি মানুষ যাতে সেফে থাকে যাতে নিরাপদে থাকে আমরা বিশ্বাস করি আসসালামু আলাইকুম